Okay, so let's start with prayer then. Dear God, we just thank you so much for the wonderful God that you are. We know that we're going through a very strange time in our lives right now, different challenges for each one of us and different questions about what's going to happen in the future, but we know that you hold the future. We know that whatever goes on, if we're in a relationship with you, then whatever happens will work out. Doesn't mean we won't have to weather the storm. It means you'll be there during the storm. You'll be there through the storm and when the storm is over. I just ask for a special blessing on each of the students, special challenges each of them is having in their own lives. They'll stay healthy, they'll stay safe, and they'll be able to meet all their needs that have to be met. We just ask this in your name. Amen. Okay, so if nobody's going to show themselves, then I'm going to get rid of the gallery view then. Okay. All right. Okay. All right, so we're on chapter 8. That's page 181 of your book, and there is an essay. There is an essay question that is on basically this issue is essentially basically page 181 to page 195, which is most of the chapter. Okay, 181 to 195, basically having to do with the steps between arrest and trial for the most part, okay? So steps between arrest and trial, page 181 to 195 is an essay choice on the final exam. So basically between the time the police actually make an arrest and the case is either resolved at trial with sentencing or some other things, or a number of steps that are taking place, and all those steps kind of fit under the broad heading of psychology and psychological implications. By the way, I just found out, if anybody's interested, I am going to be teaching psychology of family and marriage again this summer on Thursdays. If anybody's interested or needs that one, that's my traditional summer course, Marriage and the Family. An interesting course for the 21st century, let me tell you. Okay, so obviously when we look at things, the trial is what we see the most. That's what's the most visible. In many ways, maybe the most dramatic, but there's lots of other things that are involved, and some of those things are very important to determine the actual outcome beyond the trial. Obviously, between the time there's an arrest or basically at least weeks and sometimes months and sometimes even years take place before the cases are either dismissed for lack of evidence or the prosecutors proceed. Of the 56,000 felony cases filed in May of 2009 in the 75 most populous counties in the United States, 25% were dismissed before ever reaching formal prosecution. Most of those occurred because of plea bargains. We're all familiar with plea bargains, okay? So most people charged with crimes who don't have the charges dropped usually end up plea bargaining. And civil cases are similar. Most civil cases are solved without a formal trial with something called settlement negotiation. And those we don't see. We don't see what's going on between the district attorney and the defendant. We don't see what's happening between the litigants in a civil case. In criminal cases, many times we would know the result, but in civil cases, we almost never know what happened. And so psychologists have done a lot of research and trials. They have a lot to say about that, but maybe not so much to others. So in addition to plea bargains and settlements, we'll also talk about other pretrial proceedings in criminal cases like pretrial motions and bail setting, those steps that are involved. And so basically, we're going to talk about, at the beginning, we'll talk about the basic normal sequence of things go through. So on page 182, talks about steps between arrest and trial. So being arrested and actually being charged are actually two separate events, okay? Basically, the arrest is made by the police or another law enforcement official, but the actual charging with a crime is actually done by the prosecuting attorney. So following an arrest, an initial appearance is the next thing that takes place in the criminal process. Fourth Amendment, the Constitution says any person arrested must be brought before a judge within 48 hours of arrest. It may not sound right, but it does happen that way. In a lot of places, that's not true. A lot of countries, people can be arrested and held for indefinite periods of time, but under our Constitution, that's not possible. So he has to appear before a judge or a justice of the peace, or some type of judge. The primary purpose is for the judge to look at the evidence as it exists so far and decide if there's reason enough to believe that the suspect might really have committed the crimes. The judge also at that time will inform the defendants of what his charges are and remind them of their constitutional rights, and talk about bail, talk about attorney being appointed if they can't have an attorney. So that's the initial appearance. Following the initial appearance would be the preliminary hearing. And again, the idea is to try to get rid of cases in which there's not enough evidence, basically a waste of taxpayers' money. There's no jury present, and defendants rarely even talk about or say anything at all. The judge will then sometimes send the case to a grand jury. We'll talk about grand juries in a minute. Or the judge may have the right to reduce the charges, either because they don't believe there's enough evidence or because there's been a plea bargain taking place. So a number of things can happen. All right, the next major thing is a grand jury. I don't know if anybody's ever served on a grand jury before, and you guys are not showing your hand, so I won't ask you. So basically a grand jury, my wife served on a grand jury one time. A grand jury comes from the same pool of people that constitute the normal juries. And the grand jury meets in private with a prosecutor. It may not be the district attorney, it might be an assistant district attorney. There's no defendants there. There's no defense attorneys there. It's just a grand jury and somebody representing the prosecution. And basically the evidence is presented to the grand jury, and then the grand jury makes a decision about whether or not they think there's enough evidence for it to go to trial. The grand jury has a lot of latitude. The grand jury can basically call anybody they want to ask questions. The grand jury also has access to the defendant's prior record, which the normal jury does not until the sentencing phase. And so there's a lot involved there. And if they decide the person should go to trial, then they return what's called an indictment or a bill. And so the indictment is the formal complaints that are prepared by the prosecutor. The grand jury, again, can do lots of stuff. In some states, the defendant has a right to testify, but in about 1/3 of the states, a criminal defendant cannot be questioned unless the grand jury has specific reasons why they must do that. Most cases, it doesn't take place, okay? In the other states, the prosecutor can either do grand jury indictment or preliminary hearing. If the grand jury decides there's sufficient evidence, then they issue an indictment. And you'll find out if you ever serve on a grand jury, if you're in a jury panel and somebody asks you if you've ever served on a grand jury, and you say yes, you won't likely be put on a criminal panel. That's primarily because one of the experiences my wife got from being in a grand jury is that she found out it is really, really difficult to send somebody to trial, and nobody's going to trial unless the prosecutor and the grand jury are pretty well convinced the person is guilty. So therefore, she would have a problem with the idea of a person's innocent until proven guilty because that would create some issues for her as well. So, all right, so after the grand jury is the arraignment. So the grand jury passes his indictments to a judge, and then the judge calls for those indicted to come to court for an arraignment, okay? The arraignment is where the judge makes sure that the defendant has an attorney. If they don't have one, then the judge will make arrangements for an attorney to be appointed by whatever system is involved, wherever it is. It could be a public defender, or in some cases is a rotating thing between local attorneys in the jurisdictions where there's not enough people for there to be a formal public defender group. Then the indictment is read to the defendant, and then the defendant is asked to plead guilty or not guilty. Typically at this time, the defendants plead not guilty, even though they may change that later. The reason for the non-guilty plea is by pleading non-guilty, then they set themselves up to where they maybe can go through some plea bargaining and also discovery process. If they plead guilty, then it's all pretty much over. So So the no guilty plea is important. All right, next section in your book is called Discovery and Pretrial Motions. In civil trials, each side is entitled to what's called discovery, okay? Discovery means you can ask questions of the opponent's witnesses, okay? And you can look at any documents they might use at the trial. In a criminal case, it's a little bit different. Just how much the prosecution has to reveal varies a lot from state to state. Some states actually require, as in a civil trial, that all information has to be turned over to the other side. Most states only require that some evidence, like laboratory reports that are called exculpatory. Exculpatory is evidence that tends to show the defendant is not guilty or suggests us an issue with credibility of the prosecution's witnesses. In other words, if there's a weakness in the prosecution's case, and they know there's a weakness, they're not really allowed to keep that hidden. They have to make that available to the defense, to be fair. Discovery basically is a two-way street. In general, most states also require the defense to turn over the same types of material the prosecution has to turn over. In a lot of states, the defense is only required to notify the prosecution if it plans on something like an insanity defense or alibi defense. The reason for that is so that the state has an opportunity to investigate why, to do their own investigation on insanity plea and to also investigate the alibi so they can confirm that. During this phase, both sides can also make pretrial motions to try to get favorable rulings on what might make evidence admissible. By the way, obviously you can't raise your hand, so if you need to ask a question, you're gonna have to turn on your mic and tell me that you're asking a question, okay? All right, motions are commonly filed for, there's a number listed in the book. One is called a motion for separate trials. If several defendants have been involved in the same act, like robbing a bank or something, then there can be a request that they be tried separately and not as a group. There's also a measure to sever counts, which is similar. That means if they're being charged for more than one offense, then the motion to sever counts would be to ask to be tried for each count differently. A good reason for that is that if the person's brought before a jury and they're listed as a bunch of offenses, then the jury is more likely to think the person is guilty just because there's so much evidence, okay? So when charges are combined with other charges, that increases the likelihood that the person will be found guilty, as opposed to if they're tried separately. All right, third one's the one you may have heard a lot of movies and stuff. It's called a motion for a change of venue, okay? Basically, you're being asked to be tried someplace else. That typically occurs because, especially in a smaller community, if the defense believes that because of pretrial publicity and the number of people available, it's impossible in the local area to get a jury that's impartial, and sometimes they'll ask to go to some other place. So maybe like somebody commits a crime in Lubbock, and it's in the Lubbock newspapers and on TV all the time, and so somebody asked to move it to Abilene or Amarillo in the hope that they wouldn't have been paying attention to local stuff. So you'll see that it isn't necessarily often granted because it's a very expensive process, but in a serious enough trial like a murder trial, it might happen. All right, the fourth motion is a motion to suppress a confession or other statement by the defendant. In other words, maybe the process of being arrested, process of being interrogated, the witness confessed, and now the defense doesn't want to stick with that confession. Basically, that's usually because they complain that in some way the confession was obtained in violation of the defendant's constitutional rights. In that case, a prosecutor has to file a written response to that, and then basically the defendant and the police get their versions of what happened, and then the judge makes a decision. The fifth one is called motions in limine. And that basically is just a request for a pretrial ruling. Could you decide in advance certain things about the trial? All right, next major section is called the decision to set bail. And in other words, is the defendant going to be required to stay in jail until the trial, or can they be released? Okay, and that's especially important because of the length of time that exists sometimes between arrests and trials in our day and age. And so if a person is presumed to be innocent, then they shouldn't be in jail if they're innocent. But the flip side of that is if a person's charged with a serious enough crime, there's a likelihood they just might decide to leave town and just escape, especially like a murder conviction or something. So basically, the judge has a number of options. Again, in the case of like a capital murder trial, it's not that uncommon for judges to say no bail. The person has to stay. Basically, the judge can require a deposit be given to the court as a pledge that the person will return to trial. Okay, and so you have bail bondsmen. They basically, you pay them a certain percentage, like 10% or something, what the bail is, and then they're guaranteeing the other 90%. And when you show up, then they get to make some money. You get some money back. You can also do it with a third person taking responsibility and willing to give up their money. But the bottom line is, if somebody's going to give up money if the person doesn't show up for trial, and the hope is that'll get them there. So obviously, how much the bail is set is dependent primarily upon two big factors. One factor is how much money does the person have. Obviously, if you tell Bill Gates he's got to pay a $100 bond, he's going to say, I don't have that small a change. On the other hand, how serious a crime is makes a difference too. The reality is most defendants who promise to show up do show up. So it's not really clear whether bail bonds actually make a difference. The Eighth Amendment to the Constitution says excessive bail should not be required, but it doesn't define what excessive is, and it doesn't guarantee a right to bail. It just says that if bail is required, it shouldn't be excessive, whatever that means. So what are the considerations that affect the decision to set bail? That starts on page 185. Legal factors are related to the offender's legal histories. This is a person who's been tried for crimes before, who's maybe skipped out on bail before. That would make a difference. Extra legal factors have to do with things that shouldn't be there, but there are issues like gender and age and ethnicity that might affect the judge when they shouldn't. Okay, next section on page 187 says, does pretrial release affect trial outcome? Basically, obviously, if a defendant is kept in jail, that can affect their attitude for sure. By the way, if a defendant is kept in jail and if part of their sentence is a jail sentence, then the time they've been in jail awaiting sentence usually counts towards the time they're supposed to serve. That's time served. So defendants who are kept in jail are more likely to plead guilty and receive longer sentences than those who can afford bail, even if the crime is serious. That's just a mathematical statistic. So is it really possible to decide what's a high-risk defendant? Okay. Around 1970, we started pushing for laws that would increase the use of what's called preventive detention. That's the idea of, keeping people detained who are a risk of flight, or maybe they're just would be dangerous to be out there, okay? If you have a serial killer, do you really want the serial killer running free? Civil libertarians obviously oppose this because they believe that it conflicts with the concept of innocent until proven guilty. And that is one of the whole big issues. If you're really innocent until proven guilty, that puts some questions in this whole idea. But it's very difficult to decide what really should be done, like most important topics. Okay, that brings us to the next major topic, which is plea bargaining. If you're following along in your book, that's on page 188, okay? So it's estimated that somewhere around 95% of all criminal cases end prior to trial, okay? Typically what's called plea bargaining, where the defendant pleads guilty to some lesser charge, and that gets them out of the heavier charge. And a plea bargain occurs a lot, and that goes back to, we talked about what are some of the major ideas about what is a criminal justice system about. And if you decide, is it about truth or is it about conflict resolution? Obviously, plea bargaining is all about conflict resolution. It's about not going through the hassle of a trial, not going through the expense of a trial, but getting some type of punishment. We've been using plea bargaining in our country since the 1800s. And in many cases, you know, it's, as I said, maybe 95% of people do that. Trial business is almost gone. Basically, murder defendants are less likely to plead guilty than defendants charged with other felonies, which makes sense, okay? The harsh sentences associated with convicted murderers, which is, if not capital death, is at least life in prison without parole, makes it better for the murder defendant to go on trial and hope that the jury will let him go entirely, because even plea bargaining is still going to get him, you know, very, very long prison time. From the defendant's point of view, in order to plea bargain, you've got to plead guilty to something, okay? So that's the defendant's part. If you're going to plea bargain, they have to say, well, I'm guilty of something. I agree to be guilty of this. What the prosecutor is trying to do, of course, is reduce the number of charges. That might be one way. Okay, we're not going to charge you for this. Maybe it's a charge of attempted robbery or actual robbery and attempted murder because of shooting at a guard. And so maybe they would drop the attempted murder charge. So basically, so you can choose, plea bargain for lesser charges or plea bargain for less numbers of charges. Charge bargaining is one where the prosecutor drops some of the charges to get a guilty plea. The flip side of that is sometimes it's like a dealing, right? You go to bargain with somebody, and so you start with a higher price and you're willing to accept, or you start with a lower price and you're willing to pay in order to try to work your way up. So sometimes prosecutors are guilty of just throwing in lots of charges that maybe they would have a lot of difficulty proving, just to give them something to do away with, which is really kind of maybe a little sneaky, but overcharging does seem to work. We can also do sentence bargaining, where basically in return for a guilty plea and not going to trial, then maybe the prosecutor agrees to go for a lighter sentence. Okay, so maybe in the case of capital murder in a state where the death penalty is legal, maybe the agreement would be to drop the death penalty and maybe drop the life in prison without chance of parole, something like that. Sentencing, though, ultimately is a judge's decision, and judges don't always follow the prosecutor's recommendations, but many times they do. So why do defendants plead guilty in the first place? There's a number of reasons, okay? One reason, obviously, is because there's a lot of evidence out there, and it's pretty clear that they're very likely to be found guilty. If they face some long sentence. So that's one reason to plea bargain, because they know it's not going to go well, so they're trying to get by with something easier. Basically, defendants plead guilty to get less severe punishment than they would receive. But why do prosecutors go along with that? Well, prosecutors are motivated to plea bargain for a number of reasons. One, of course, is maybe they're recognizing that their case isn't as strong as they would like it to be, and maybe their defendant has a really powerful lawyer or something, and they recognize that they might have trouble selling this in the actual trial, so then they go for it. Another is if in some political arenas, and remember, district attorney is a political position, the number of wins is important versus the number of losses, and a plea bargain where a person pleads guilty counts as a win, okay? Sometimes the plea bargain is there so that a lower level criminal will be a witness against a higher level criminal. That's the ones you see in the movies all the time. And then sometimes it's just the fact that there's maybe just too many cases out there, and they're just trying to work cases through the system and cut down the system overload. Obviously, when this pandemic is over, there's going to be a lot of cases that have built up, although there should have been actual, I don't know, I hesitate to say there's been less criminal activity, because in some cases there might have been more. All right, so basically, plea bargaining helps a defense attorney if they can show they've done something for their client. I can say, so look, we got you down. So that's kind of a win for them. So what are the psychological influences on the process? Well, one way to get somebody to go along with what you're asking from either side is you present your idea in terms of gains rather than losses. Look what you have to gain, not what you're losing. What's called the overconfidence bias basically is where either side is where the defendants or attorneys think they have a chance to win, and they might reject what's a reasonable offer from the prosecutor just because they're so sure they can win. Basically, and another part is, even though we talk about lawyer-client privilege, a lot of defendants are really not willing to admit to their attorneys what they're guilty of, maybe not even to themselves. All right, there have been a number of studies to decide how well plea bargaining works. They talk about it on page 191. It's still pretty controversial. People say it's an important, necessary part of the criminal justice system. Others have condemned it, and it should be done away with. Those in favor of the plea bargaining process say that, well, it helps cut down the backlog of cases, gets people through the system faster, which is fair. It makes it easier to at least prosecute offenders for something. And basically, it also helps the criminal justice system because trials require police officers and stuff to be in court when they should be out on the street. Critics, of course, say either it should be abolished or at least changed in some ways. They say, number one, that the sentence is improper. Sometimes, even though it's a plea bargain, it's really too harsh. Sometimes it increases the likelihood that a defendant will give up their constitutional rights. Sometimes innocent defenders actually feel the pressure to plead guilty just because they're afraid of being convicted of something worse, and that prosecutors have too much power. Also, there's a criticism that plea bargaining takes away the right of the defendant's families to see justice done and to see the person acknowledge that they're responsible. Basically, criticism is that a person shouldn't be able to plead guilty to a reduced charge simply because the system can't handle them. All right, that's criminal cases. Let's look at settlement in civil cases. That's on page 192, talks about settlements in civil cases. Again, as in criminal cases, the vast majority of civil cases are settled without a trial through what's called settlement negotiation, where the parties involved, their attorneys, negotiate back and forth on what they're willing to accept. Okay, remember, in a civil case, somebody wins and somebody loses. Most divorces, landlord-tenant disputes, claims of employment discriminations, and accident cases are settled without a trial. Basically, lawyers involved because they prefer the fact that they're going to get something out of a compromise when the jury might totally do something different. And judges, of course, also because of the docket of cases, would prefer that things get settled. So what are some of the factors that determine the actual amounts that people get in settlement? Well, obviously the legal merit should make a difference, you know. Well, the person was drunk when they were driving and they ran it to my house or whatever, that makes a difference, okay. But there are other factors as well too. According to negotiation theory, just like any other negotiation, each negotiator has what's called a reservation price. That's their bottom line, you know. What's the least I'm willing to pay or the least I'm willing to accept? So for the defendant, their reservation price is the maximum amount that they're willing to pay to settle an agreement. For the plaintiff, their minimum amount is the reservation price. What's the minimum I'm willing to accept and feel like I got out of this okay? When you're evaluating their cases, people basically, as in real life, have trouble seeing the merits of the other side. They always believe the evidence favors their position, and so that makes it a little bit unrealistic sometimes. And basically, you can kind of see that if you're watching the news lately, in this whole situation going on in the world, you're just seeing all sorts of people out there expressing all sorts of opinions that really have little or no basis in reality, and wanting things that are unreasonable. Well, the government should have been able to prevent the pandemic. I'm not sure exactly how that would have taken place. Okay, I guess a crystal ball, and you know what's happening, and before things break out in China, you shut down the country. But anyway, lots of weird ideas on both sides. Okay. All right, that finishes that section. That brings us to page 195 and another test question. Okay, in this case, it is a short answer choice on the final exam, and that's what is the purpose of a trial. So that's basically page 195 to 196. It's just a couple pages there because it's a short answer question. Remember, that's 3 or 4 sentences is what you're looking for, okay? So what's the purpose of a trial? Obviously, every trial, when you talk about a criminal trial or civil trial, you're seeing 2 versions of the truth, okay? In a criminal trial, one side says the defendant's innocent, the other side says they're guilty. In a civil trial, you have each side claiming about who's responsible for what. And the idea is to present their facts, whatever they are, in a way that will convince the judge and the jury to go along with what they say. Okay. Trials also serve other purposes. Again, they're conflict resolution. They do that. They provide a sense of stability to our criminal justice system. And basically, again, on the concept of conflict resolution, people feel like they've come out, they've had their side presented, and they've had a chance. So we talked before about there's 2 different approaches to things. And one approach is the concept of the trial as a search for truth, okay? So truth or conflict resolution. In terms of truth, to a lot of people, we're trying to find out, is the person really guilty or not? In a civil case, who is really responsible and responsible to what degree? But that's been challenged on a number of reasons. One has to do with the trial as a test of credibility. Basically, this acknowledges the idea that in criminal and civil cases, we don't know everything, we don't have all the evidence, we don't have all the information, and we're working with less than everything we need to know, and so it sometimes comes down to a matter of who is the most believable, okay? But there's some problems there, okay? The bottom line is that basically, there are problems with credibility because obviously judges, attorneys, juries sometimes make decisions on extra legal factors, things like the age or gender or ethnicity or wealth status or whatever the individual makes a difference, okay? All right, the third one is that maybe the trial is a conflict resolving ritual. We said that conflict resolution, and that's basically, it's just, we're just trying to resolve a controversy. Of course, if we talk about trials as being stabilizing, if the public doesn't believe the trial is fair, then that changes things. Basically, beyond a reasonable doubt, that's a certainty required for criminal conviction. That's sometimes hard to come by. All right, the rest of the chapter is not a test question, so you can rest for a minute there while I finish out the chapter, and then we'll get to the next chapter. How are we doing on time? Okay, about an hour. All right, so we're still good, Colton. All right, so steps in the trial process. Okay, we have the preliminary actions. We've kind of talked about this already. Obviously, one of the pre-trial selections is selection of the jury, okay? And there's a 2-step process, and we will talk about this more later. And again, I'd hope to have an attorney come in and talk about it, but again, obviously that's not going to happen, okay? So the first step is to get a panel of prospective jurors, what's called a venire, and basically, like in Lubbock County, there's a list of all the registered voters and people with driver's licenses that are 18 years old. In Lubbock County, that would be your panel of prospective jurors, okay? And so basically out of those, in some supposedly random fashion, a venire for a particular trial is selected. Once the venire is selected, then those people, however many there are, 40, 50, 60, 80, whatever, go through what's called a voir dire process to basically question and select who's going to actually be the jurors. The idea behind the voir dire is to figure out if there's some prejudices, biases, lack of the ability to be an impartial juror that's going to keep you from being dismissed. Just having a busy work schedule is not going to get you dismissed. Okay, basically a question of whether or not you'll be fair. The trial itself, whether it's a criminal case or civil case, there's similar steps. They usually begin with what are called opening statements. The attorneys for the defendant in either criminal or civil trial get to choose whether they want to make their opening statement after the other side does theirs, or wait until it's their turn to turn the evidence. Okay. Basically, psychologists wonder about this. Typically, if the defense opening statement is given earlier than the later, verdicts are more favorable to the defense. And when that happens, then that makes the defense attorney look better. And basically, it has to do with the idea of proactive, reactive sort of thing, proactive learning, the idea of recency, and basically whether or not we hear something at the beginning, at the end. We talked about that before. It makes a difference both ways. Okay. So anyway, typically, defense gets to decide how they want to do things. After the opening statements, then the prosecutor, or in the civil case, a plaintiff, calls his witnesses first. So regardless of who made the opening statement first, the one who's prosecuting, the one who's suing, the other ones who talk first. Each witness testifies under oath. If they lie under oath, and that's what's called perjury, which is a crime. Okay. So once the witness presents his testimony, led by the prosecutor, then the defense gets to cross-examine, and then once the cross-examination is over, then the original attorney gets to redirect their question. Basically, redirect usually occurs if, let's say, in this case, a prosecutor feels like the defense attorney has weakened their witness, so basically it's called impeach the witness, and so they're trying to basically restore confidence and credibility of the witness. So the purpose of redirect is to what's called rehabilitate the witness, to try to basically get the jury thinking back to the original testimony. But then, of course, the defense, once again, has the opportunity to recross, and so they get to talk again, okay? Same thing is used in the civil trial as well. Once both sides have presented their witnesses, then they can decide whether or not they want to introduce additional evidence or additional witnesses, what's called rebuttal evidence, based on what's been brought up before by the other people. Sometimes you don't want to get into a certain area unless the other side gets into it, then you're ready to go there. Once all the evidence has been presented, then each side is given the opportunity to present what's called a closing argument, a closing statement, or summation. It varies from place to place. As a general rule, the prosecution gets the first summation, and the defense gets their summation, and the prosecution speaks again, plaintiff speaks last. The idea is that the defendant should have the right to have the last word. Then the final stage then is for the judge now to give instructions to the jury as to what the procedures are. In the case of criminal charges, the jurors are reminded that they must be convinced beyond a reasonable doubt. That's not beyond a shadow of a doubt. That's a movie someplace. Beyond a reasonable doubt, that defendant is guilty if they're going to vote to convict. What reasonable doubt is tricky, but generally it means that they should be strongly convinced. It doesn't mean there can't be a little lingering doubt. In a civil trial, it's totally different. Okay, remember, in a criminal trial, you're trying to decide if the defendant is guilty or not, and basically you're assuming they're innocent. You have to decide, the jury has to be convinced that the person is guilty. All or nothing. In a civil trial, that's not true. In a civil trial, it's what's called preponderance of evidence, okay? In other words, in a civil trial, somebody wins, okay? And you just have to decide which side you think has the most convincing argument, and that goes on from there. All right, page 198 talks a little about sentencing. That's the last phase. Once the defendant's found guilty, then the punishment has to be decided. In most cases, most places, the trial judge decides the punishment, okay? In the past, they used to have a lot of discretion there, but it's got more tight since 2004. And basically, it's different. In some states, sentencing is actually determined by the jury. In cases involving the death penalty, it's always done by the jury and not by the judge. All right, that ends chapter 8. Let's go to chapter 9. And again, no notes yet. I'll let you know if you need to take notes. This is going to go fairly quickly, I think, anyway. All right, chapter 9 is alternatives to judicial prosecution. The first one it talks about is what's called alternative dispute resolution. Most cases are resolved through negotiation or what's called alternative dispute resolution, and very few cases are settled in trials, as we know. In federal courts, it's even more settled outside of court than even in regular courts. Same thing true for civil trials. A number of reasons. And one, of course, is the fact that going to trial costs a lot of money. So it's called transaction costs. Also, in addition, federal courts put pressure on litigants to settle or for defendants to plead guilty. Basically, federal sentencing guidelines are different, and they provide incentives. The judges have more authority, and so it's easier to push for plea bargaining and settlement. Basically, in both state and federal courts, judges can sometimes require cases to be settled without going to trial. The arbitration is another process. So negotiation is one way things are done. Arbitration, so negotiations when the two sides get together and come up with an agreement. In arbitration, what's called bounding arbitration is similar to a trial. Basically, the parties agree to a binding arbitration, which means they agree to bring in a third party called an arbitrator, and they agree to abide by whatever the arbitrator says. There is such a thing as non-binding arbitration. In binding arbitration, the people must go along with whatever the arbitrator said. In non-binding arbitration, if one side is dissatisfied, then they could ask to go before a judge or a jury. Basically, however it's done, arbitration is handled a lot like a trial. Another thing is called the summary jury trial. That's a variation on arbitration. You have a jury, and the lawyers, you don't actually have witnesses. What you have is the attorneys tell the jurors what the witnesses would have said, which sounds weird. And the lawyers argue the case and try to answer the jurors' questions about the facts. The judge tells the jury what the law is and answers any questions the jurors may have on the law. And then the jury meets, deliberates, decides the case. Okay. Originally, in the olden days, in a summary trial jury, the verdict by the jurors is not binding, but in recent years, a lot of those have become more binding. But it's still possible to go both ways. All right, so negotiation, two people meet together, try to solve it, two sides. Arbitration, a third party comes in and decides what the answer is. Mediation is another form. Mediation basically is you have a third person, but the third person is just there to help you get along, not to make decisions, okay? It works with the litigants to try to achieve a settlement, okay? They don't have any authority as an arbitrator does, but they're just a facilitator, okay? So that makes it kind of different than arbitration, okay? And there's a lot of opinions about alternative dispute resolution, whether it's a good idea or not. Okay, if you're following along in your book, let's jump over to page 272 and talk about what are called problem-solving courts, okay? These are what are called specialty courts. And basically, the original idea was to help people with certain types of problems and that it got them involved in the criminal justice system in the first place, but to keep them out. So that's part of what's called therapeutic jurisprudence. We're trying to make things better for the person, try to keep them out of trouble. So that would include drug courts, mental health courts, so things like homelessness, domestic violence, all those things, veterans issues. Basically, you can use mental health courts to help with domestic violence cases. Drug courts you might be the most familiar with. That's the most common type of specialty court. Tries to deal with offenders whose crimes have to do with their addiction. Okay. Mental health courts, I mentioned those. Homeless courts, domestic violence courts, community courts, veterans courts. Those are all different types of specialty courts, okay? All right, page 218 talks about the criticisms of problem-solving courts. They have been criticized. They do have the potential to reduce recidivism rates. Remember, recidivism has to do with a person committing the same crime over and over again and make things better for the participants and families. And so they'll probably tend to do better because most people are happy. All right, that's chapter 8 and 9. All right, so basically, I guess the question is, are you guys comfortable enough with this that we will keep doing this for the next several weeks? Everybody okay with this? Anybody not
Yeah,
okay?
I'm good with it.
How about the 6:30 time? Is that okay? Would you rather do 6?
That doesn't matter to me.
Yeah, either one's fine.
I just figured 6:30 avoided the things that people, except it didn't in this case, avoid the problems with people maybe not getting here quite on time. And so I think we'll probably stay with 6:30, if we're not going to go too late. And that way you don't have to rush so much. Obviously you're not going anywhere anyway, right? So really it's save you a lot of time. All right, and this is what we do. If you read the announcement on Blackboard, then I stopped with the thing requiring you all to turn in your notes starting tonight, and so we'll just add one more paper towards the end. Anybody have a problem with that?
No, that's fine.
That's fine.
I did say that last week before the final. It is a week in between, so well, I'll just leave it as the last week before the final. If you want to turn in earlier, that's fine too. So we'll just add one more. That's 50 points. There would have been 5 classes with 10 points. That means you don't have to write out all your notes and send them in to me, okay?
So what kind of, I did the article on chapter 8. So what's the next article on?
Okay, the articles can be on anything.
Okay.
You misunderstood that. The articles can be over anything in the book. It doesn't have to be over something for the week or something we're covering in the past. Okay, that's
Right.
a good question. That's a good question. Any topic that we've talked about or will talk about that you're interested in. So this is what, number 3 tonight? Is that right?
I don't remember.
Number 3.
3 or 4.
Somewhere I got a piece of paper. I see here. That's number 4. Yeah. All right, number 4. So this is number 4. So even with the extra one, you only have 3 left.
So 3 plus the extra one.
Well, if this was number 4 tonight, right?
Yes.
Then there's just 5, 6 in the extra one.
Oh, okay. So 3. Okay.
3. Okay, so that's not bad.
No.
So any problems with that with just doing an extra one instead of turning it? It should be less work than turning in 5 weeks of notes, right?
Yes.
Okay. All right. And actually, I guess I recorded this, so I guess I'll post the recording. And then if you feel like you've missed out.